Shall we start? So let me just introduce dignitaries, seniors, and my fellow friends and speaker of the day. Let me thank all of you for joining today's knowledge sharing session on issues in cross-border mergers and acquisitions. We have total got 85 registrations, including tax aids of corporates, partners of leading law firms, and legal counsels. Binoy will be taking today three different types of situations in cross-border M&A, namely inbound mergers, outbound mergers, and share purchase transactions. Yeah. So before I introduce Binoy, let me just give few instructions. Participants can raise their questions through chat box at the end of the session. And if they want to supplement their question, they can raise hand and they will be unmuted. During the session, we will be conducting a poll which would be allowed for live for 15 seconds, in which you can give feedback of the speed of the session, and accordingly feedback can be passed on to the speaker. Yeah. With this, I would like to introduce Binoy. Binoy is part of M&A team at PwC and KPMG and have significant experience in the areas of promoter handholding, deal conceptualization and execution, succession planning, and corporate restructuring from a commercial, tax, and regulatory perspective. As a chartered accountant and a lawyer, he has broadly worked in the following areas like corporate group restructuring involving listed companies, streamlining overseas structures, strategizing and structuring fund infusion, pre-IPO structuring. He has dealt with various tax and regulatory laws such as income tax, FEMA, FDI policy, securities laws, including SEBI takeover code, insider trading regulations, listing regulations. Also, he has dealt with stamp duty, Ind AS, IFRS, RERA, and Indian private trust laws. He has also co-authored several articles pertaining to the M&A field, including publication of a chapter giving insights on impact of general anti-avoidance rules on holding structure, published in a compendium of GAR published by BCAS. With this brief introduction, I will request today's learned faculty, CA Binoy Parikh, to take charge of the session and enlighten us on the today's topic.
So good evening, everyone. So before I begin, of course, I hope and pray that you and your families are healthy in these very trying times. And thank you, Pratik, for that introduction. So what I'll be doing over the course of the next 1.5 hours is I will be walking through broadly three themes in relation to cross-border M&A and tax issues around it. Basically, three themes. First will be inbound mergers, so a foreign company merging into an Indian company, and what are the critical or what are the tricky issues around that. Similarly, a converse situation, which is an outbound merger, an Indian company merging into a foreign company, which is a very new concept. And lastly, share acquisitions and overseas merger, which do not involve a merger, but it directly involves only share acquisitions. And lastly, as certain takeaways, what are the key facets we need to keep in mind at the time of entering into a share purchase agreement? I'll just walk upon a few brief aspects around that. So with this, I'll just start my presentation. So what are the laws around cross-border M&A in India? So as you can see from the screen over here, is basically three laws. One is the Income Tax Act 1961. Second is the Companies Act 2013. And third, and one of the most important facets, are the FEMA regulations. So all three by itself have an interconnectedness And of course, in the commercial backdrop, all three laws have to be addressed, because if a structure is not permissible pursuant to a particular regulation, then the structure is not permissible at all. So tax benefits aside, while I acknowledge that this session is in relation to the tax issues surrounding cross-border M&A, we need to be cognizant of the regulations that surround it. And therefore, while the large focus will be on the tax issues around cross-border M&A in this session, we'll also briefly touch upon certain regulatory facets so that we have a holistic understanding of the issues surrounding the cross-border M&A. So with this, let me just start by introducing the first theme, which is inbound mergers. So effectively, inbound mergers are mergers where a foreign company is merging into an Indian company, and it could involve foreign shareholders or Indian shareholders or a combination of the two. Now, so let's look at case study one. So what I've done is, in the course of this webinar, I have divided all the three themes into various case studies. And the idea over here is really to understand the practical aspects in relation to a particular structure and the theoretical laws around it. So the first case study over here is that we have a group of shareholders owning an Indian company. An Indian company is owning a foreign company. Now, the foreign company doesn't have any operations. Foreign company could have operating downstream subsidiaries overseas. Now, foreign company doesn't have any operations. It only has cash, and the idea is to repatriate the cash back to the Indian company. So therefore, one option over here, and plain vanilla option over here, is that the foreign company could simply dividend out the cash to the Indian company. Now, as obviously you would know, any dividend which is received by an Indian company is taxed at the rate of 15% under Section 115 BBD if it is received by the Indian company. And now that the DDT is scrapped, if it is passed on to the shareholders, you may receive a credit, but obviously there's a gap over there. So effectively, the Indian company would be taxed at a rate of 15%. And therefore, is there any alternative around that? One of the other consideration over here is that there are no operations in the foreign company, and therefore the foreign company runs the risk of being classified as a passive company, and therefore the poem of such foreign company could be considered as being in India, and therefore the income of such foreign company could be in India. Given these risks, the answer to that could perhaps be a merger of a foreign company into the Indian company. So therefore, it will effectively be a foreign company which is a 100% subsidiary merging into the Indian company. What will happen as a result of this is that the entire cash or the surplus profits which were forming a part of FCO's balance sheet would now be vested in the books of Indian company. Now, of course, since FCO is a wholly owned subsidiary of the Indian company, as a result of the merger, there won't be any issuance of shares by virtue of Indian company being the 100% holding company of the FCO. Now, in this context, there are a couple of questions which we need to understand. So first, I will deal with certain specific sections, and then we'll deal with the larger question of whether there is any implication under GAR or not. So, as you can see on the right, there are three main sections which I'd like to discuss. One is there any deemed gift provision under section 56 to 10? So effectively what is happening is that ICO is receiving a sum of money from FCO, in consideration of which it is not giving anything, because obviously it itself is the shareholder. And therefore, whether there could be any deemed gift provisions under section 56 to 10 is the question. Now over here, what will come to the rescue is the definition of amalgamation under section 21B. So in this case, since all the properties and liabilities are becoming the properties and liabilities of ICO as a result of amalgamation, it should be considered as a tax neutral amalgamation, and therefore it will satisfy the conditions of section 21B. As a result of which, if it is a transaction referred to under section 47.4, which is 47.6, which is effectively capital gains taxation for FCO into ICO, then it is specifically exempted under 56 to 10, and therefore there shouldn't be any deemed gift provisions under ICO because of the fact that an amalgamation is specifically exempted. But this was pretty straightforward. So let's look at two other tricky issues. Now, here the main purpose of this amalgamation, if it is only that I want to repatriate cash, then therefore can the department recharacterize the transaction as a deemed dividend by applying the provisions of section 222A, which effectively says that any distribution of assets by a company to its shareholders is considered as a deemed dividend in the hands of the shareholders. Now, very interestingly, first, let's deal with the question of SAR, because section 222 effectively is a specific provision as opposed to GAR, and therefore let's deal with the specific provision. So as I was mentioning, interestingly, in 1967, when section 21B was introduced, the CBDT had come out with a circular that if a company is merging with any other company, and if the profits are embedded in the assets of such company, then effectively that merger, since it is a tax neutral merger, otherwise it will not be considered as a deemed dividend in the hands of the amalgamated company. So in the context of this specific case study, since FCO is merging with ICO, although the assets are embedded, the accumulated profits are embedded in the assets of FCO, it shouldn't be considered as a deemed dividend under 222A specifically. Now, insofar as deemed income provisions are concerned, so say for example under section 224.4, so 224.4 says that any value, any benefit which is derived by the shareholder of a company is considered as an income in the hands of the receiving shareholder. Now, in this particular case, since ICO is receiving the cash of FCO without necessarily paying anything in return, because FCO will cease to exist, whether this can be considered as income in the books in the hands of ICO, the answer to that is it should not be considered as a deemed income because of the fact that it is specifically exempted under section 47, 56 to 10 and various other provisions. Now, of course, if there is a overarching risk of GAR. So if there is no commercial rationale for this merger, and if the sole purpose of this was to obviate the need of paying a tax on dividend, then obviously any of these provisions can be invoked. The amalgamation can be nullified and can be taxed as dividend in the books of ICO. So, for example, if an FCO does not have any operations, has sold all its subsidiaries, and it is anyway liable to be liquidated, then it could perhaps be substantiated as a commercial rationale that I don't need an FCO in a foreign jurisdiction, and therefore I'm merging it in ICO. So that perhaps could be one commercial rationale, but dehors or devoid of a particular commercial rationale, it runs a risk of being recharacterized as a dividend. So that's insofar as repatriation of profits is concerned. Now, one regulatory note over here is that under the 56 Act and under the 2013 Act, inbound mergers were always permitted, and therefore, and RBI also came up with particular regulations in the form of EMA cross-border merger regulations, which also permit inbound mergers. One important point over here is that the jurisdiction of FCO should also permit outbound mergers, because what will happen is that FCO will merge with ICO and it will be considered as an outbound merger in the jurisdiction of an FCO. So Mauritius, for example, permits. Singapore doesn't permit. So the next case study is in relation to such jurisdictions where an outbound merger is not permitted. Now, here effectively what we are looking at. So again, the facts remain the same. Shareholders owning an ICO owning 100% of FCO. FCO doesn't have any operations and it only has cash. Now, FCO is in a jurisdiction where outbound mergers are not permitted. So therefore, what it does is, So there'll be two steps to this. One is that there will be a scheme of arrangement in the foreign jurisdiction, an arrangement between FCO and its shareholder, whereby FCO will be liquidated without necessarily, so FCO will be liquidated without necessarily being considered as a merger. At the same time, ICO will file a scheme of arrangement under Section 230 to 232, whereby the undertaking of FCO, which is effectively the residual cash or the profits, will be vested with the ICO. And therefore, pursuant to this hybrid arrangement, whether this can be considered as a tax neutral arrangement or not. So again, to reiterate, the cash will come in the books of ICO as a result of liquidation, but that cash, if it is defined as an undertaking in a scheme of arrangement in the Companies Act, then that vests with the ICO pursuant to the NCLT approval. So therefore, the first question over here in terms of the tax implication is whether this will be a Section 21B compliant liquidation or a merger or not. So 21B defines amalgamation as in a particular manner. It says that it is a merger of two or more companies, whereby the assets and liabilities of the foreign company become the assets and liabilities of the ICO. Now, neither the term merger is defined, nor is it defined that what does merger of two companies mean, whether it should be combined. It's not there. So it prescribes a particular manner in which a merger is said to be an amalgamation within the definition of 21B. And therefore, if all the assets and liabilities become the assets and liabilities of the ICO, then it should satisfy the definition of amalgamation within the meaning of 21B, especially because it will be supplemented by a scheme of arrangement under Section 230 to 232. Having said which, there is no necessary, there is no obvious reason why there was a scheme of arrangement filed with the NCLT over here. And therefore, if one looks through this hybrid arrangement, then it is obviously a liquid distribution of cash pursuant to a liquidation. And therefore, we have a very specific section over here, 222C, which deals with the fact that if there's a liquidation and if there is a distribution of assets from a foreign company to ICO, then it will be considered as a deemed dividend in the books of ICO, and it can be recharacterized as a dividend in the hands of ICO. And therefore, the key point over here is that while we may structure it as a hybrid arrangement such that it is considered as a merger in India, there's a high likelihood that the merger will be disregarded and it can be considered as a deemed dividend. Now, one question over here is that if it is not pure cash and if there are some operations, some activities in FCO, and that undertaking, which will include the employees, which will include the cash, which will include the other assets, is vested with ICO, can this arrangement be considered as a transfer from a wholly owned subsidiary to a 100% holding company? And the result of this, obviously, is that can we take shelter under 47.5? Now, here it is a very peculiar scenario because what happens in case of 47.5 is that it only talks about a transfer of a capital asset from a 100% subsidiary to its holding company without necessarily, and that transfer is not considered as a capital gains. So, therefore, there could be an argument that this can be under 47.5, but the other sections which follow 47.5 and protection of capital gains are not satisfied. So, for example, section 47A, where the relationship between the holding company and FCO is not maintained for a period of 8 years, then the transfer will be considered as a capital gains tax event. Now, in this case, obviously, that won't be the scenario because FCO is being liquidated. So, in the context of the follow-on conditions, that maintenance of relationship, there being a capital gains in the first place, all those conditions, the basic ingredients of 47.5, while apparently they are satisfied, uh, in the context of the other provisions, the shelter under 47.5 looks unlikely that it will pass the muster, and therefore there are high chances that such distribution of cash to the ICO will be considered as a deemed dividend under 222C because there's a specific deeming fiction to this effect. So moving on, so there's a slight variation from case study number 1, but a more riskier option as compared to a pure merger because of the very fact that it is structured in the form of a hybrid arrangement. So moving on, case study 3 deals with a cross-border demerger. So case study 1, we saw a cross-border merger, and case study 3 deals with cross-border demerger. Now, what makes this fascinating is not the tax issues. We'll deal with the tax issues. But what makes it fascinating is the discord between Section 234 of the Companies Act and the cross-border merger regulations prescribed by FEMA, and a positive precedent to this effect passed pursuant to an order passed by an Ahmedabad NCLT. So, under Section 234 of the Companies Act, effectively the words that are used for a cross-border merger is that a merger and amalgamation of a foreign company with an Indian company is permitted, subject to prior approval of an RBI. Now, RBI had prescribed cross-border merger regulations where it didn't restrict the term cross-border merger regulations as to only merger, but it used a wider term and it included arrangement. So any arrangement between a foreign company and an Indian company is also considered as a cross-border merger within the definition of RBI rules. So we have a subordinate legislation in the form of FEMA regulations. We have a mother provision in the form of Section 234 of the Companies Act. And therefore, the key question over here is that whether cross-border demerger is permitted or not. Now, in the facts of this specific case, we have, and this is, by the way, the Sun Pharma case, which was approved by Ahmedabad NCLT. We'll come to that in a bit. So the facts of the case over here were that there was an ICO, which is a listed company. It owned 100% of FCO, and FCO held 100% of FCO2. Now there was a demerger of an undertaking directly from FCO2 to ICO. So therefore, the question over here was that such a demerger, whereby FCO2 is not merging with ICO but demerging its assets, is permissible or not. This case was dealt with in the case of Sun Pharma, as I had mentioned, and Ahmedabad NCLT had passed a favorable judgment in this regard. It said that you have to construe the provisions of Section 230 to 232 mutatis mutandis when you are interpreting Section 234. Therefore, what effectively it means that the terms merger and amalgamation, if they are constructively interpreted, then it should include demergers also. And the consequence of this was that the demerger directly from FCO2 to ICO was permitted. So this was a regulatory hurdle that was pleasantly crossed in the case of Sun Pharma. Now there are various tax implications in relation to this, which warrant an analysis. So four main questions: whether, first of all, this demerger will be considered as a tax neutral demerger under Section 219AA. So Section 219AA defines demerger to mean a transfer of undertaking from one company to another, whereby the properties and liabilities pertaining to that undertaking become the properties and liabilities of the Indian company, and 3/4 in value of the shareholders of FCO2 become the shareholders in the resulting company. So demerged company is FCO2 and the resulting company is ICO. It obviously has an exception that if there are shares which are held directly or through its subsidiary by the resulting company, then such shareholders, then the requirement of issuing shares to the shareholders is not necessitated, which is the present case because FCO2 is a 100% step down subsidiary of ICO. So ICO indirectly through FCO holds shares in FCO2, and therefore there is no condition or precondition to issue shares at all. Having said which, therefore 47(6)(b), any transfer of capital asset to ICO will be considered as capital gains exempt in any case, the horse of 219AA exemption or not. There is no obvious reason why there should be a capital gains exemption, because there is no Indian asset or Indian income which is accruing in the book in the hands of FCO2 at the time of demerger. So therefore, while it is tax neutral, 876B is a good to have provision, but not at all necessary to have a provision insofar as FCO 2 is concerned. Now, having dealt with FCO 2, let's look at why 219AA is necessary, why we need it to be a tax neutral demerger. So the real reason is the second question, as I've mentioned on the right hand side of the presentation of the slide, is section 56 to 10. Now, section 56 to 10, again, as we had seen in case law number 1, deals with the fact that if you are receiving any consideration, or if you are receiving any property uh, and you are not issuing any shares, or there is an inadequate consideration, then it will be considered as a deemed gift in the hands of ICO. Now, there are two defenses over here. One is that if it is a tax neutral demerger, then there's a specific exemption under 56 to 10 in the hands of ICO that such receipt of property will not be considered as a deemed gift, even if you've discharged, say, less than adequate consideration, which will be so in this case. The second condition and the second distinction over here is the definition of property under 56 to 10 itself. So property has been defined in a particular manner under 56 to 10, and it includes illustratively land, building, shares, securities, paintings, jewelry, etc. Now, in case of a demerger, and we have various precedents to this effect. In case of a demerger, what is the property being transferred? It is effectively the undertaking which is transferred, and therefore the undertaking is the capital asset which is being transferred as a whole. So therefore, the undertaking may have assets and liabilities within its fold, but it also has many other aspects such as contracts, legal proceedings, if any, and therefore any or all the properties, assets, contracts, legal proceedings, employees, etc., which are being transferred from FCO2 to ICO is considered as an undertaking. And therefore, since even if it is non-tax neutral, there could be a possible defense to say that it does not come within the fold of 56 to 10 because an undertaking is not a property as defined for the purposes of 56 to 10. So that's the second provision if it is not considered as tax neutral. Now, the third interesting question over here is that whether it can be. Now we looked at it from we looked at this demerger from the perspective of ICO and FCO2. Now there is one loose end over here, which is the intermediary company, which is FCO. Now, from an FCO's perspective, can it be considered as a deemed dividend? Because what effectively it means is that the assets which were held by FCO indirectly, because through FCO2, are being distributed to ICO. So while the investment in FCO2 continues to stay in the books of FCO, FCO2's assets are being distributed to ICO. Now, as I had mentioned in case law number 1, there was a specific 1967 circular which said that any accumulated profits embedded in the assets of a company are, I mean, they can, even if so, it won't be considered as a dividend. You can draw same analogy for demerger, but there's no specific circular to this effect. So the converse to this is that if there is no circular to this effect, then it can be considered as a deemed dividend. And now that the DDT is not there, in any case, it will be liable to tax in the books of the ICO if it is considered as a deemed dividend. Similarly, from a deemed income provision under 224(4), can it be said that FCO has given a benefit to its shareholder, that is ICO? The reason is that ICO should have given something to FCO or FCO2, but FCO and FCO2 are being devoid of any consideration. So it did not be in the form of shares. Now, the regulations aside, first of all, shares cannot be issued from the perspective of Companies Act because a holding company cannot issue to its subsidiary. But could there be a case where you could have given, say, a cash consideration or something? Now, FEMA regulations aside, there could be a commercial imperative that you could have discharged the consideration in the form of cash. And to that extent, which is not being discharged, FCO or FCO2 have given a benefit to ICO in the form of transfer of undertaking without any consideration. And therefore, ICO runs a risk of an income being accrued in its hands on the receipt of the undertaking, the horse of 56(2)(10). Now, of course, we have a provision which obviates this need, but 224(4) risk remains if it is considered as a value of benefit which is distributed by FCO or FCO2 to ICO. So therefore, while a cross-border demerger is permitted or pursuant to the Sun Pharma case, there are a couple of risks which one needs to bear in mind in case of a demerger from a 100% subsidiary to its ICO. Now, this equally could apply from in the case of a demerger from FCO directly to ICO, because the risk of 222A and 224(4) will continue to remain, even if it is considered as a tax neutral demerger. So moving on. Now, this is an interesting case study. So we have a Mauritius company as a shareholder. It holds shares in Mauritius company MCO over here in the green box, and it holds shares in an ICO. Now, this is a post 1st April 2017 structure. Now, what is happening over here is that MCO is merging with ICO, and ICO, in consideration of that, is issuing CCDs. Now, effectively, what it means is that let's look at the tax implications from three perspectives. One is the Mauritius company, which is a shareholder in the gray box. One is a transferor entity, which is MCO in the green box, and one is ICO, which is a recipient entity. Now, in this case, from an MCO's perspective, obviously this will be an amalgamation which satisfy the conditions of 2(1)(b, and therefore, from an MCO's perspective, it should be considered as a tax neutral merger, because under 47(6). Now, in any case, MCO's only asset, if it is ICO, then the shares are getting extinguished, and therefore there is no transfer to ICO, and therefore in any case there shouldn't be any capital gains implications for MCO. Insofar as ICO is concerned, it is first of all, if it is a tax neutral merger, which it is, then there should not be any 56(2)(10) implication, because it is specifically exempted. And similarly, if from the perspective of Mauritius company, if shares were issued, then it would have been a tax neutral merger. But in this case, what we are specifically mentioning is that there is an issuance of compulsorily convertible debentures and not shares. So here the merger itself is not a tax neutral merger, because one of the conditions is that the shareholders of the amalgamating company should become the shareholders of the amalgamated company, and by virtue of issuance of a quasi equity instrument, they don't become shareholders. They still continue to hold debt instrument, and therefore if it is not tax neutral in this context, whether MCO will be subject to any capital gains, the answer should be no, because the shares the shares of ICO which are held by MCO are getting extinguished, in lieu of which MCO is not receiving anything, because MCO ceases to exist. Similarly, there shouldn't be any 56(2)(10) implication in the books of in the hands of ICO, by virtue of the fact that ICO is issuing shares, and therefore it should be considered as an adequate consideration for extinguishment of the property. In any case, it is not receiving any property in the first place. So 56(2)(10) is out. So therefore, the real question is that whether there should be any tax implications in the hands of the shareholders, which is the Mauritius company. Now, in case of the Mauritius company, can we take a benefit under India Mauritius DTAA? Now, here what happens is that Mauritius company there will be a capital gains implication in the section 9, because the shares of MCO are getting extinguished, in lieu of which it is receiving CCD, and therefore there is a capital gains trigger of indirect transfer tax under section 9. However, under India Mauritius DTAA, Mauritius company, there could be a case relying on the Sanofi decision of Andhra Pradesh High Court, whereby we can rely on Article 13(3)(a). Now here effectively what happens is that, is this a gains arising from alienation of shares in a company which is a resident of a contracting state, may be taxed in that state. So over here, what happens is that the Mauritius company is deriving gains in a company which is a resident of a contracting state, may be taxed in that state. So therefore, under the India Mauritius DTAA, Mauritius company is alienating the shares of MCO by way of extinguishment of shares, and therefore it shall be taxed uh, in which the company is a resident of. And therefore, interestingly, what happens is that effectively the tax is shifted from India to Mauritius under Article 13.3A. And therefore, effectively, this means that even if it is not a tax neutral merger, uh, relying on the relying on Article 13.3A, there won't be any taxability by virtue of this particular tax shelter. Interestingly, what this translates into is that the CCDs, if you had invested, say, 10 rupees in the shares, and if you are being issued CCDs of 50 rupees, then effectively, since it is not a tax neutral merger, Mauritius company as a shareholder should get a tax cost step up uh, in its hands when it subsequently sells the CCD. So therefore, this is an interesting case study by virtue of the fact that by making it as a non-tax neutral merger, effectively it results in a cost step up in the books in the hands of the Mauritius company. Now, why CCD? What was the need of the merger? Was it specifically to target cost step up? All those questions can be questioned under GAR, and therefore, uh, plain vanilla merger obviously won't work, but it has to be substituted or it has to be supplemented by a strong commercial rationale. So moving on, this is last case study insofar as inbound merger is concerned. So we have an IP company in say Ireland, and it doesn't have any assets in India. We have foreign shareholders who none of whom are Indian shareholders or none of whom have owned anything in India. This Ireland IP company is merging with an Indian company. Now, Indian company is issuing shares to the foreign shareholders. So therefore, first question is that is the tax exemption relevant? Because there is no accrual for the Ireland IP company in India because there's no assets which are owned by the Ireland company in India. Neither the foreign shareholders have any assets or income accruing in India because they held the shares of an IP company, and therefore there shouldn't be um, any need or requirement of a chargeability under Section 45 because no income is accruing either in the hands of foreign shareholders or Ireland IP Co. Now, in relation to this, therefore, what it means is that effectively, if there's no Section 45 chargeability, and if this is not considered, I mean, I don't need a definition of tax neutrality over here. And if I'm issuing shares, therefore, the IP which is acquired by ICO, can there be a cost step up of the IP which is acquired by ICO? The answer to that could be yes. The reason is that there is no requirement of of this merger being a tax neutral merger. And insofar as 56 to 10 is concerned, for example, in the hands of ICO is receiving IP for sure, but it is also issuing adequate consideration to that effect. And therefore, there is no real need of this merger being a tax neutral merger. And therefore, one could possibly argue that without Section 45 being triggered, uh, Section 21B and Section 47 providing for tax exemptions is not relevant, and therefore, cost step up for IP in the books of ICO should be possible. But of course, one could also argue that otherwise it was a tax neutral merger, and therefore there shouldn't be any there shouldn't be any cost step up. Having said which, therefore, the fourth box, as I've mentioned on the right hand side column, is that can you cement the cost step up by issuing CCD? So you make it as a non-tax neutral merger, issue CCDs, and can that result in a cost step up? So the answer could be a yes. Now again, commercial imperatives, for example, Indian shareholders didn't want the foreign shareholders to own direct equity ICO and therefore CCDs, but CCDs are quasi equity. So what was the need of issuing CCDs? All those questions can come up uh, in the GAR scrutiny. But having said which, this is a possible structure which one can look at for a cost step up of, say, an IP which does not have any asset in India. Insofar as the regulations are concerned, issue of any other debt instrument is not permissible. The reason is that FEMA 20 are now replaced by non-debt instrument regulations, specifically only provide for issuance of equity instrument which includes CCDs. So shares or CCDs or CCPS are the only permissible instruments which is possible without an RBI approval. And in this context, obviously, RBI approval will be hard to get, and therefore any other instrument is not permissible. So uh, moving on to the second theme, outbound mergers. Now, outbound mergers are a relatively new concept because they were not there in the 56 regulation, 56 Act, Companies Act. They are there under 2013 Act, and it was only later, after 5 years, that the RBI came up with regulations providing for a permission for outbound mergers. So it's a relatively new concept in the Indian scenario. So now let's look at a plain vanilla structure. So we have Indian shareholders owning a manufacturing company in India, and there are certain other shareholders owning foreign company outside India. Now, what is effectively being contemplated is that the manufacturing company will merge with the foreign company, in lieu of which the foreign company will issue shares to the Indian shareholders. Now, first challenge is the regulatory hitch. Now, the outbound mergers provide for a fact that if there's a company which is merging into a foreign company, then the residual office which continues to be in India will be treated as a branch office. Now, if it is treated as a branch office, then we'll have to comply with the provisions of FEMA. Now, if it is a proper manufacturing setup, then it is not permitted in India. A foreign company is not permitted to carry out manufacturing activities through a branch, and therefore, there itself, the outbound merger for a pure manufacturing company can will not pass the muster of outbound merger regulations. So there's a very limited list of activities for a foreign company to conduct its operations through a branch in India. Manufacturing is not one of them. Insofar as the tax implications are concerned, there could be various tax issues over here. First of all, this merger will be subject to tax in the hands of two entities. One is manufacturing company, and the second is its shareholders. So, insofar as manufacturing company is concerned, it is transferring the capital asset to the foreign company, and therefore there could be a tax implication in the hands of the foreign company as a successor company of the manufacturing company. Secondly, and as a double whammy, the shareholders also could be taxed. The reason is 2001 Supreme Court judgment of Grace Police, which said that any extinguishment of shares is considered as a transfer within the definition of Section 247 of the Income Tax Act, and therefore any shares which are received are consideration for that extinguishment and therefore subject to tax as capital gains. So there could be a tax liability in the hands of FCO as a successor company. There could be a tax liability in the hands of shareholders as well. So in this context, outbound mergers still need to evolve because there's no specific provision providing for a tax neutrality for outbound mergers. And there are, of course, going forward implications for Indian operations, because what effectively will happen is that the Indian operations of the manufacturing company will be considered as a permanent establishment in India, and therefore a foreign company will be subject to a much higher tax rate in India for the profits derived by that permanent establishment, as opposed to an Indian manufacturing company which easily could have been taxed at say 25% in the new corporate tax rates. So given these deficiencies, outbound merger may not be a completely viable option at this stage. So moving on, here we saw a case of two unrelated companies. Now moving on, can there be a case to argue that in case of a merger of a 100% subsidiary, which is an Indian company, with a foreign company, which is with its parent, can be a viable option? So in the facts of this case, we have foreign shareholders owning a foreign company, and a foreign company owns an Indian company. Now, Indian company has virtually wound up its operations, so it doesn't have any operations, it doesn't have any risk of permanent establishment, etc. if it is merged, and it only has cash. and therefore ICO is merged with the foreign company. Now, can there be a capital gains tax risk insofar as this is concerned? So first of all, whether it is Section 2(1)(b) compliant. So Section 2(1)(b) is a very bare shell definition. It says that a merger of two or more companies is considered as tax neutral if the assets and liabilities of the amalgamating company become the assets and liabilities of the amalgamated company, and company includes a body corporate incorporated pursuant to the laws of a foreign jurisdiction. So therefore, yes, it could be a 2(1)(b) amalgamation, but are there any capital gains implications for the ICO? So yes, there will be capital gains implications. The reason is in order to avail the capital gains tax exemption for the transferor company, which is ICO in the present case, the amalgamated company needs to be an Indian company. So amalgamated or the transferee company over here is a foreign company, and therefore capital gains exemption for ICO is not available. And therefore there is a risk of a successor tax liability for FCO because of the fact that the cash is received pursuant to merger and there is no tax exemption. Similarly, there is a double whammy. Now, what happens is that the shares held by FCO in ICO are getting extinguished. Of course, it is not receiving anything in relation to that in terms of issuance of shares, but it is receiving the undertaking of ICO. And therefore, there could be a capital gains implication in any case in the hands of ICO, regardless of the fact that it's a successor tax liability or not, because it is receiving cash in lieu of extinguishment of shares. And therefore, by various other provisions as well, for example, 222 deemed dividend, 224(4), various other facts, again, a merger of 100% subsidiary with its holding company uh, could run a risk of being classified as a taxable event in the hands of FCO. And therefore, again, outbound merger is a very new concept and has all these challenges to deal with. So moving on, this is the last practical case study for outbound merger. Again, the precedent is Sun Pharma, and what had happened over here is that the shareholders own a listed company, ICO in this case, and it is demerging and undertaking to its 100% subsidiary. So therefore, it is a case of an outbound gift or a demerger. Now, the logic over here was that it is transferring the undertaking from ICO to FCO within the fold of arrangement, the term arrangement which is used under the FEMA regulations. But it is not, FCO is not issuing any consideration to ICO. The obvious reason could be tax implications in the hands of ICO. And therefore, over here, the question from a regulatory perspective was that whether such an arrangement where an undertaking is being transferred from an Indian company to its 100% subsidiary is permissible or not. So Section 234 clearly talks about the fact that it should be a merger and amalgamation. Extending it, we saw in the earlier case, it could be extended to a demerger, provided that it's a demerger in the first case. In this case, however, in the case of Sun Pharma, it was not so, and the NCLT had held that such an arrangement of providing for an outbound merger will not be permissible within the fold of either the FEMA regulations or the Companies Act, and therefore the scheme providing for this arrangement was not approved. Assuming that it had been approved, could there have been tax implications? So from an ICO perspective, uh, there is no consideration being transferred from there is no consideration being issued by FCO to ICO, and therefore it's effectively a corporate gift. Now there are various judicial precedents that a company can give to another company, and therefore there should not be any capital gains in the hands of ICO because it is not receiving any consideration. The converse is that whether FCO could be taxed under 56(2)(10). Again, as we saw earlier, property is defined in a particular manner, and undertaking is not a property as defined in the 56(2)(10). So, on a pure technical reading, one could argue that there is no tax implication in the hands of either ICO or FCO. but of course, it's a risky proposition in the first place. And in any case, given the regulatory roadblock, an outbound demerger will not be permissible. So moving on, and the last theme of today is the share transfers and overseas mergers. So there are a couple of case laws which we'll look at. So the first case study, and again, it's a plain vanilla case study. We have a Mauritius company owning an ICO 1, and we have an ICO 2. So there is a merger which is contemplated by ICO 1 into ICO 2, and there is an issuance of shares by ICO 2 to the Mauritius company. Now, over here, one fact is that Mauritius company had acquired the shares of ICO 1 prior to 1st April 2017. Now, interestingly, what is happening is that the shares which were held by Mauritius company in ICO 1 are getting extinguished, in lieu of which it is being issued new shares. And therefore, effectively, this will translate into Mauritius company acquiring new shares post 1st April 2017. And therefore, the question is that can this obviate or can this jeopardize the benefit under the India Mauritius DTAA? So the answer to that on a pure reading of the India Mauritius DTAA is yes, it could jeopardize. The reason is, so just as a background, couple of years back, there was an amendment which was introduced in the India Mauritius DTAA, which said that any shares which are acquired after 1st April 2017 are sold. Then the capital gains arising from such sale will be taxed in the source country, which is India in the present case. And therefore, if Mauritius company were to sell the shares of ICO 2 in future, can there be a risk of capital gains in the hands of Mauritius company? So the answer to that is yes, there is very much a likelihood of Mauritius company being taxed in India. And the reason for that is that the shares of ICO 2 are acquired uh, post 1st April 2017, which is today, albeit the period of holding and all continues under the domestic law, uh, and it relates back to the date of acquisition by MCO in ICO 1. But the acquisition of shares of ICO 2 is definitely post 1st April 2007. And therefore, there's a huge risk of MCO being subject to capital gains when it sells the shares of ICO 2 in future. One, one argument is that if the period of holding and the cost of acquisition relates back, then can it be deemed to be acquired pre 1st April 2017? The likelihood of that argument being accepted looks weak, and the reason is that the word acquisition is different from the word transfer, and there is no linkage, unfortunately, between the word acquisition and the word transfer. Acquisition used in the India Mauritius DTAA and the word transfer, which is used in the domestic law. And therefore, again, as I had mentioned, there is a high likelihood of this of capital gains when MCO sells the shares of ICO 2 in future. Now, there are certain practical considerations for listed companies. So, for example, if ICO 1 were to be a listed company, ICO 2 also were to be a listed company, then uh, there could be a scenario where you will need the buy-in of FPI shareholders. So, if there are certain portfolio investors in the listed company, then you may need to check with them that would they be okay with such a scenario, because what this will mean is that they'll lose the benefit of pre 1st April 2017 acquisition. And therefore, this is a very sensitive point, because capital gains which otherwise would not have been taxable will now be taxable when the portfolio investors or any other non-resident investor uh, they sell it uh, after 1st April 2017. So therefore, this might be a practical consideration for a listed company, and a buy-in of foreign portfolio investors could be a challenge in this particular scenario. So moving on, case study number 2. So in this case, Again, this deals with an indirect transfer tax provisions. So we have Mauritius shareholders at the top, which own Mauritius Company 1. Mauritius Company 1 owns Mauritius Company 2, and Mauritius Company 2 owns Indian Company. Now, there are no other assets in Mauritius Company 1 or Mauritius Company 2, and therefore, for the purposes of Section 9, Mauritius Company 1 and Mauritius Company 2 derive their value from the Indian company. So therefore, in this context, the transaction is that the Mauritius shareholders will sell the shares of Mauritius Company 1 to the buyer shareholders. And therefore, under Section 9, since MCO 1 and MCO 2 derive substantial value from Indian company, Mauritius shareholders will be subject to tax in India under Section 9, under the indirect transfer tax provisions, basically the Vodafone case. And therefore, when Mauritius shareholders sell to the buyer shareholders, there will be a capital gains implications under the Indian Income Tax Act under Section 9. However, can there be a case to argue that there is a shelter provided under the India Mauritius DTAA under Article 13? Now here, let's just look at the language. So here what is happening is that the Mauritius shareholders is alienating shares of another Mauritius company. Now, typically, if Mauritius shareholders had directly alienated shares of an Indian company, then the way in which Article 13(3)(a) would have read is that gains arising from alienation of shares of an Indian company may be taxed in India because the Indian company is a resident of India. However, as you can see on the bottom of this slide, it says that in the context of this particular structure, it says that gains from alienation of shares in a company which is resident of a contracting state may be taxed in that state. Now here, gains arising from alienation of shares of a Mauritius company would be taxed in Mauritius because Mauritius company is a resident of Mauritius. And therefore, there could be a case to argue that there shouldn't be any capital gains implications pursuant to this Article 13(3)(a). Now, there is a judicial precedent in the form of Sanofi, whereby the Andhra Pradesh High Court had held that in case of indirect transfer provisions, it should be the resident country in which there is taxation and not the source country. Now, if in the case of Sanofi, it was an evolved structure and it was not a structure which was set up just prior to the sale or something of that sort, and therefore there was a strong commercial justification that I would have naturally sold the shares of MCO 1, which anyway would not have been taxed in India, and therefore there was a commercial rationale to that. In this particular case, for example, if it is an evolved structure, then yes, sure, there can be a case to say that there is no taxability. However, if it is not an evolved structure and if it is set up like that, for example, why did the Mauritius shareholders not directly acquire shares of an Indian company? Why did Mauritius shareholders acquire through MCO 1 and MCO 2? Why did the buyer shareholders not acquire shares of Indian company? If those challenges are not addressed, if those commercial imperatives are not addressed, then there could be a case where it could be considered that this shelter is not available. So therefore, it again depends a lot on the commercial imperatives of selling Mauritius Company 1 and this and the veracity of the structure itself of a double layer structure. So therefore, one needs to be cognizant of the commercial imperatives in this context. Now, case study number 3 is a slight modification of case study number 2. So case study number 2, we had seen a transfer of shares. Case study 3, we are seeing a merger of foreign companies. So in this particular case, again, the facts remain the same. So Mauritius shareholder owning shares of MCO 1, MCO 1 owning shares of MCO 2, MCO 2 owning shares of an Indian company. Now MCO 1 is being merged with MCO 3, completely unrelated party, and MCO 3 issues shares to the Mauritius shareholder. Effectively, therefore, MCO 3 will start owning shares of MCO 2, and MCO 2 will start owning shares, will continue to hold shares of MCO 3. Therefore, the question is that whether this is a tax neutral arrangement or not. Now, there was a specific section 47(6)(a)(b), which was introduced, whereby it said that merger of MCO 1 into MCO 3 will be considered as a tax neutral merger, provided there are certain conditions. In this case, it will be satisfied. But largely, it will be considered as a tax neutral merger. And therefore, MCO 1 is, and there shouldn't be any Section 9 deemed capital gains tax implication in the hands of MCO 1 because of a specific exemption under Section 47(6)(a)(b). However, there is another set of shareholders who are liable to tax. And who are these? Who are these parties? Basically, in this case, it will be the Mauritius shareholder. The reason is that the shares in MCO 1 are being extinguished, and therefore, pursuant to the decision of Grace Collins, uh, it will be considered as a transfer. And therefore, in consideration of this extinguishment, MCO 3 is issuing shares, and therefore, it's a capital gains event in the hands of a Mauritius shareholder. And there is no exemption insofar as the Mauritius shareholder is concerned. So, therefore, any issue of shares by MCO 3 to Mauritius shareholders will be considered as a capital gains tax event in the hands of Mauritius shareholder. This effectively means that pursuant to Section 9, there is a risk of Mauritius shareholder being taxed in India. However, as we saw in case study number 2, uh, can Article 13(3)(a) again come to the rescue of the Mauritius shareholder? Because what happens is that the alienation of shares is that of a Mauritius company, and Mauritius company being a tax resident of Mauritius is only taxed in Mauritius, and therefore you are effectively obviating the capital gains tax liability in India and shifting from source to the residence-based taxation, and therefore nullifying the impact of Section 9. So yes, again, subject to the commercial imperatives, there could be a strong case to say, especially in the context of Sanofi, that the tax liability is localized in Mauritius and it does not percolate down to the Indian source. So moving on, and I think this is the last case study insofar as uh, today's session is concerned. We have certain other takeaways insofar as share purchase agreement is concerned. So this is an interesting case study. So we have ICO 1 Indian shareholders owning shares of an Indian company, and we have a foreign holding company which is owning shares of an ICO 2. Now, effectively, what is envisaged is that ICO 1 demerges the shares, demerges its undertaking to ICO 2. But ICO 2 doesn't issue shares. It is the foreign holding company which issues shares to the Indian shareholders. So therefore, again, to reiterate, the transaction is that ICO 1 will demerge its undertaking to ICO 2, in consideration of which foreign holding company will issue shares to the Indian shareholders. First of all, the first question is that such a hybrid arrangement where the undertaking is transferred to a 100% subsidiary and shares are issued by its 100% holding company, whether it is a tax neutral transaction under Section 219AA or not. So here we refer to Section 241A, the definition of a resulting company. So resulting company is defined to mean both holding company and its 100% subsidiary. And therefore, if we look at the definition of resulting company, both foreign holding company and its 100% subsidiary could be considered as a resulting company or resulting companies in plural. And therefore, Section 219AA ought to be satisfied because all the properties and liabilities are being transferred from ICO 1 to ICO 2 insofar as that undertaking is concerned. 3/4 of value of shareholders are becoming shareholders in the resulting company and in the same proportion. So 219AA conditions should be satisfied by virtue of the definition of resulting company. Having satisfied, let's look at the tax implications. So first, insofar as ICO 1 is concerned, is there a tax exemption which is available insofar as ICO 1 is concerned? So the relevant section over here is Section 47(6)(b), It says that the undertaking being demerged from ICO 1 to ICO 2 is not subject to capital gains tax, provided that the resulting company is an Indian company. Now, this is very important because over here, on one hand, we are saying that the foreign holding company and ICO 2 are both resulting companies, and therefore, one resulting company is a foreign company, one resulting company is an Indian company, and therefore, from an assessee's perspective, 47(6)(b) could be interpreted to say that yes, the resulting company, insofar as the recipient company is concerned, is an Indian company, and therefore 47(6)(b) is satisfied. The department, however, could argue that the resulting company is both foreign holding company and ICO 2 uh, taken together, and therefore the resulting company in this context is not an Indian company. So therefore, but obviously from a purely a receipt perspective, ICO 2 being the recipient of the undertaking and it being an Indian company, 47(6)(b) on the face of it should looks to be satisfied, but the department could argue otherwise. So that is insofar as 47(6)(b) is concerned. Now, are the Indian shareholders immune to tax under capital gains or 56 to 10? The relevant section again is for section 47(6)(b). Now, in this case, what is happening? Any transfer or issue of shares by the resulting company in a scheme of demerger is not a taxable event if the resulting company issues shares. Now, here there is no requirement of the resulting company being an Indian company. So one could very well argue that insofar as the issuing company is concerned, if it is a foreign company, that is very much okay, and the Indian shareholders should anyway not be subject to tax. And therefore, effectively, what it means is that while ICO could be at a risk of capital gains, the shareholders largely should be immune from capital gains tax liability, and therefore 56 to 10. But insofar as ICO 1 is concerned, there could be a case to say that foreign holding company not being an Indian company is subject to capital gains tax under section 47. That is what the department could ask. Now, insofar as FEMA is concerned, because as I had mentioned earlier, while something may be permissible under tax, it is not necessary that it is permissible under FEMA. So here, whether issuance of shares by a foreign company to an Indian shareholder is permissible under FEMA or not. So effectively, as a result of this, what are we achieving? So effectively, what are we achieving is that an Indian shareholder will own a foreign holding company, and therefore it will be considered as an outbound investment by an Indian shareholder in a foreign jurisdiction. Now, an outbound investment specifically permitted is specifically permitted only in certain scenarios. For example, if it is an Indian shareholder, Indian individual shareholder, then it is only permitted up to $250,000. If it is an Indian company, then it is only permitted up to 400% of its net worth. And therefore, can this be considered as an overseas direct investment is the question. Now, on the face of it, effectively, there is no investment being made by the Indian shareholders in the foreign holding company. It is by virtue of a demerger that it is receiving shares, but there is no investment which is made by the Indian shareholders overseas, and therefore there is no money flow which is moving from Indian shareholders to the foreign company, and therefore one could argue that yes, there is no specific prohibition under FEMA to deal with this, and therefore it should be permitted. The alternate to that is that the RBI could say that effectively, if the Indian shareholders had sold the shares of ICO, then it was a pure Indian transaction. Now it is selling shares of a foreign company, and therefore it is not. It is a cross-border transaction. Effectively, there's a value shifting which is happening, and therefore it is not possible. So, depending on the facts of each case, who are the Indian shareholders, whether it's a company, where the foreign holding company is situated, whether there are any subsequent transactions following this, will need to be looked at in a thorough detail before we conclude anything insofar as FEMA is concerned. So with that, I think I'm done with the case studies, but I have a few certain takeaways given the complexity in tax and regulations insofar as the share purchase agreement is concerned. So if there's a share purchase agreement, what are the practical aspects that we'll need to keep in mind before concluding on the share purchase agreement? So the first point that I've mentioned over here is that if there's a if the seller is incorporated in a low or a no tax jurisdiction, say for example Mauritius, and the shares are acquired prior to 1st April 2017, the first and the foremost test would be that whether there is a valid TRC in place. Now, TRC does not guarantee you that there will be any tax liability, but there should be a TRC for the buyer. So why is this necessary for a buyer that he should check this? Is for the reason that when the buyer is paying consideration to a non-resident shareholder, then it is subject to a withholding tax on the income which is accruing in India for the foreign shareholder under Section 195. And therefore, if it is a tax exempt, if it is a tax exempt transaction, if in this particular case, if it is acquired prior to 1st April 2017, then and the department says that no, there is no substance to this, then as a representative assessee, the buyer could be subject to a tax, a withholding tax default under Section 201, read with 195. And therefore, the first and foremost thing for a buyer to check is that whether there's a valid TRC in place for the seller. Now, insofar as the second point is concerned, even if there is a TRC which is concerned, there have been numerous cases whereby the department has disregarded the TRC and has questioned the substance in the first place. And therefore, from a buyer perspective, it would be advisable for the buyer to press upon a tax indemnity. Now, tax indemnity is a concept which is very difficult to implement. As I've mentioned in the third point, there are four main facets to this. One is what is the time cap of this indemnity. So whether it is the assessment date, whether it is the reassessment date, so whether it is 3 years or 8 years, and what is the time cap, or whether it could be anything in between. Uh, so first variable is the time cap. Second is what is the amount cap, because the longer the assessment or the reassessment takes place, the amount of tax liability will increase because of the interest component, and therefore there could be this could be another negotiating factor between the buyer and the seller as to the amount cap insofar as the tax indemnity is concerned. The third is the scope itself, that whether it in the interest, I mean, if the seller is willing to provide for tax indemnity, then the scope should ideally be restricted to only the share purchase transaction and not any other transaction in its whole. Um, for example, non-compete fees or anything of that sort, which doesn't concern the share purchase. And lastly, grossing up. So, for example, if the tax indemnity amount is paid by the seller to the buyer, it will be taxed in the hands of the buyer as an income. And therefore, whether there is any grossing up liability which is provided insofar as the uh, tax indemnity is concerned is a crucial thing, and the buyer may press upon a grossing up of tax liability. The fourth point we briefly visited, there will be a withholding tax obligation for the buyer and a subsequent representative assessee liability, and therefore it is advisable to address points 1, 2, and 3. For the seller, on the converse, it is advisable to obtain a lower TDS certificate either under Section 195 or 197 in addition to the TRC. Now, of course, all these aspects are easier said than done because it involves getting something from the income tax department, and therefore it is always easier said than done. For the seller, can there be a tax insurance built into the tax indemnity? Again, the cost of tax insurance in our practical experience has been very high, and it is about 7 to 8% on the entire amount. And therefore, it will be a very costly affair to get a tax insurance, but it is still a consideration if somebody wants to consider. The seventh point is that whether any tax clearance under Section 281 are warranted. So 281 says that any transfer of a property is void at the instance voidable at the instance of the income tax department if there is tax liability which is pending, and therefore can there be a CA certificate to this effect that yes, there is no tax liability which is pending on account of this or on any other transaction, and therefore a CA certificate could be warranted, because getting a tax clearance certificate under 281 would be a challenge because it involves the department. Lastly, insofar as Section 9 is concerned, the buyer should also be cognizant of the fact that there could be an indirect transfer tax liability, and in the cases that we saw, and therefore one is that they could ask for an indemnity, and if the seller is confident that there is no indirect transfer tax provision, then they could submit the certification around that by saying that okay, there is no substantial value derived by a particular company from India, and therefore there is no Section 9 liability. So all these are certain practical aspects which balances out the need of a buyer's tax liability insofar as a rep assessee is concerned, and the seller's tax liability insofar as its tax liability is concerned when it sells the shares. So I think these are the few takeaways one should keep in mind when drafting a share purchase agreement. So I think with that, I will conclude this, and maybe I'll take up the questions now if you have any. So Pratik, over to you.
Yeah, 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 Binoy, thanks for a wonderful session. We have four questions, so I will unmute one by one. So first question is by Parag. So Parag, I am unmuting you. You can raise your question.
Yeah, hi Binoy.
Hi Parag.
Yeah, so wonderful presentation. First of all, I guess by far we never had such a practical presentation presented to us because it involved case studies and all this, cross-border restructurings. We could really see it through all the implications.
Thank
So
you.
thank you so much for that.
Thank you.
Yeah, I had a specific question with respect to case study two. You said that in a case where hybrid arrangement is there, wherein you first maybe apply for scheme of arrangement in the foreign jurisdiction, where you apply for liquidation, and then you also parallelly move a scheme in India for transfer of an undertaking involving cash,
Right.
maybe, and whether
Right.
it could satisfy conditions of 2(1)(b). So I was reading
Right.
2(1)(b. It specifically says that otherwise, then by way of acquisition of property or distribution because of the winding up. So should it not fall within this criteria and hence be out of 2(1)(b) question, and should it then become a non-tax neutral amalgamation?
No, so good question over there. Effectively, what happens in case of a liquidation, and in particular in case of schemes of arrangement, and I think UTV had done a couple of years back in 2017, is that they write specifically provide for a particular clause which says that this company will be liquidated or dissolved without necessarily winding up. So it's an arrangement between the shareholder and the company, but it is not necessarily a dissolution without winding up. So there's a specific clause which is usually provided in this kind of scenarios.
Okay, so but providing that language in the scheme should save us from 2(1)(b) exception that
Should, because it
specifically
usually
they've
in
said.
almost all the mergers that we've done, always pursuant to this merger, there is a dissolution which is not considered as a dissolution pursuant to a winding up.
Okay,
So that should
okay,
be okay.
okay, understood. Thank you.
Okay. So we have next question from Vivek Khanna. Vivek, you can read out your question.
Yeah, hi Binoy.
Hi Vivek.
Hi. Binoy, couple of questions. Number one
Yeah.
question is that in your last case study, wherein there is a overseas holding structure and pursuant to demerger, the foreign company is issuing shares, but the
Right.
undertaking is coming to the Indian company, right? 241.
That's right. Yeah. That's
So
right.
just wanted to understand how would the accounting entries work for the foreign holdco as well as the Indian holdco,
Okay.
because let's say the
Yeah.
assets are given to the ICO. Yeah, sorry, go ahead.
So let me deal with that. So basically, see, under Ind-AS 103, if it is in this particular case study, it was an unrelated demerger. Even if it is related, that's okay. So what happens is that on one hand, you are receiving, say, assets of 100 rupees. So ICO, I'll just put that case study. ICO 2, in this case, is particularly receiving the undertaking of 100 rupees. But it is not issuing any shares uh, on the liability side. So therefore, on the liability side, there will be a capital reserve which is created.
Okay.
because it is receiving something, but it is not paying for that. So there will be a capital reserve which will be created in the books of ICO 2. Insofar as the foreign holding company is concerned, and I'm assuming that IFRS is applicable for foreign holding company, what will happen is that it is issuing shares. So there's a liability, there's something on the liability side, but on the debit side, there's nothing. So therefore, there are two choices over here. One is that it can increase the investment in ICO 2 to its effect, because effectively the foreign holding company is discharging the consideration on behalf of ICO 2, and therefore uh, therefore the investment in ICO 2 can be recorded. So if you are issuing 100 rupees worth of shares, then foreign holding company will record a corresponding investment in ICO 2 at 100 rupees. So this was there. We've done certain practical schemes in relation to this. So I think that should be
So
okay.
you had debited investment in ICO 2 in the books of foreign.
Yeah. Yeah.
Okay.
Yeah,
Okay.
that's right.
And in the books of ICO 2, where you are saying that the delta would go to capital reserve, I mean the liability side, is there any Ind AS or any AS that you follow for this capital reserve credit, or it is just a normal accounting entry?
No, so even under India's, so consider a case where it is for unrelated merger. It says unrelated demerger. So it says that you have to record the assets and liabilities at fair value, and if there's a bargain purchase, then you have to credit it to the capital reserve. So in this particular case, since ICO 2 is not paying for anything, then it will be credited to capital reserve. Even otherwise, in case of a common control business combination, what will happen is that is a straightforward process, because you'll record the assets and liabilities at book value, and whatever is the difference, you'll directly credit it to capital reserve. So in either of the two scenarios, the conclusion is the same. The manner of deriving at the conclusion is different, but the conclusion is the same. And under IGAP, non-India's company, in any case, there's no accounting for demerger, because AS 14 only dealt with amalgamations and not demerger.
Right, got it. Just one last question on this: that are there any practical precedents on such a transaction in the Indian NCLT's courts?
Yes, there are. So one in the listed space, so foreign holding company, there was one, but it was, I mean, it's not there in the public forum, but I mean, the orders and all are there, but I wouldn't like to share that. But insofar as Indian companies are concerned, Thomas Cook acquisition of Sterling Holidays was one key precedent over here. It was an Indian company, but yeah. But NCLTs have approved in our practical experience in the past.
Okay. Okay. Thank you for this update, Binoy. One small question, one last question on your case study 1. Can I ask this question?
Yeah, sure.
Yeah, one small question, that where there is a merger happening between let's say foreign company merging into an Indian company, foreign was merging into an Indian company. As a result,
Right.
the cash of the foreign company comes into the Indian company and no shares are issued.
Right.
Here you said that there is a 224 issue that could arise.
Right.
Right. So just wanted to understand, if you read 224, it says that if there is a benefit or perquisite which goes to a director or to a person who has substantial interest in the company.
Right.
Right. So just wanted to understand the trigger of 224.
No, so here what happens is that effectively what is happening, what is the nature of this transaction? The assets of the Indian subsidiary are being received by the holding company, and the holding company is not discharging any consideration because you cannot discharge the consideration. So one is 224.4 can be said that it does not trigger because of the fact that there is an impossibility of discharge of consideration. So to that extent, 224.4 you are immune to that. And the reason why I wanted to highlight 224.4 is in the case of a demerger. So here in case of a pure merger, 224.4 should not be an issue. But in case of a pure demerger where the resulting company or the subsidiary company continues to remain, in that case, one could say that yes, the cash is received. You could have discharged consideration in the form of a non-share consideration, because I understand that Companies Act prohibits you to issue shares. But could you have discharged consideration in any other form? The answer is yes. So effectively, the holding company as a shareholder is receiving it for free, and therefore it's a benefit.
But that company is receiving in the under the hat of the shareholder and not a director.
No, but the person who's substantially interested.
Correct. Got
You
it.
see so if you see the second limb, not director, the person who's substantially interested.
Right. Thank you so much,
Yeah,
Binoy. Thank you for all the doubts. Thank you.
thanks.
We have next question from Hardik Shah.
I think I already asked it in the session. Yeah. It's already answered by Binoy. Thank you.
Okay. So last question is there. It is from Dhruv Kotak.
Yeah.
Dhruv, if you have questions, you can unmute yourself and raise it. Yeah. Yes, Dhruv, go ahead.
No, I don't think it is there.
We are not able to hear you. So I think. Okay, I think with this we can give it over to Chintan Shah. Just a second.
Hello.
Chintan, you can, yeah.
Hello. Binoy,
Yes.
thanks a lot for explaining all the case studies very lucidly. So I don't have any
Thanks.
question as far as case studies are concerned, but do you see any changes that any crucial implications under a cross amended space post MLI coming into force?
Sure. I mean, obviously, very interestingly, while MLI talks about a lot of other articles, insofar as M&A space is concerned, there's only one article which is relevant in that, and that is capital gains implication. So, of course, from a Mauritius tax point, from a Singapore tax point, from a Cyprus tax point, you'll have to analyze what is the transaction, because M&A is a very fact-specific transaction. So I think you'll have to just relook at that. But insofar as pure applicability of MLI is concerned, I mean, it continues to remain the same.
Okay, so basically a principal purpose test or a denial of a treaty benefit would play a crucial role.
Yeah.
Yeah, thanks, Binoy.
With this, I would request Mr. Chintan Gajjar to give vote of thanks before we conclude today's meeting.
Yes, thank you, Pratik. It's my privilege to offer a vote of thanks to today's guest faculty, Sri Binoy Parikh. As a student of international tax law, it is of utmost importance to understand the nuances of cross-border mergers and acquisitions. Binoy has very well covered and explained tax and regulatory aspects of both inbound and outbound mergers and acquisitions through various practical case studies. On behalf of all the participants, I extend sincere vote of thanks to Sri Binoy Bhai. Sir, we would be looking forward to have you once again on this platform between us as and when convenient to you. It would be our pleasure to have learning from you and your practical experience. I also thank all the participants joining here and organizers as well. Friends, we will keep you posted for the next webinar learning. We are signing off at present. So thank you all. Stay home, stay safe.
Thank you, everyone. Thank you so much.
Thanks.
Thanks.
Thank you.
Thank you.